viewers, welcome to the session Policy, Legal Framework and Institutional Arrangement for Proposed EIA in India Part 2 of the course Environmental Impact Assessment for Environmental Health. In the previous session, we have learned that EIA in India was first started in 1977 to 78 with evaluation of river valley projects. This was later extended to mining, industries, thermal power, port and harbour, atomic power, rail and road highways, bridges, airport and communication, etc. Only in January 1994, the Ministry of Environment and Forest, MEF, that is known at that time, issued a notification on EIA of development projects. We know that this notification has listed 30 projects that required environmental clearance from the central government. It also included for the first time public hearing as a prerequisite for clearing large projects. The notification made it obligatory to prepare and submit an EIA, an Environmental Management Plan (EMP) and a project report to MEFC, which had the option to consult a multidisciplinary committee of experts. The environmental authorities in India which are entitled and have a key responsibility in environmental impact assessment processes are MoEFCC, Ministry of Environment, Forest and Climate Change, CPCB, which is Central Pollution Control Board, EAC, Expert Appraisal Committee of the MoEF, SEIAA, that is known as State or Union Territory Environmental Impact Assessment Authority, SEAC, State or Union Territory Expert Appraisal Committee, and SPCB, which is known as State or Union Territory Pollution Control Board. The decision making responsibility has been given, or the authority responsible for the evaluation and final decision in the environmental impact assessment process are MoEFCC, Ministry of Environment, Forest and Climate Change, and SEIAA, State or Union Territory Environmental Impact Assessment Authority. According to this, the definition of EIA is that EIA aims to foresee and address the potential environmental problems at an early stage of planning and design of new projects or expansion or modernization of any activity, and to impose restriction and prohibition on the expansion and modernization of any activity or new projects being undertaken in any part of the country unless an EC has been accorded by the federal or the state government in accordance with the specified procedure. The environmental impact assessment is also used to ensure that project or its environmental management plan complies with other important environment related legislation. Environmental impact assessment integrates the environmental concerns in the development activity right at the time of initiating for preparing the feasibility report. In doing so, it can enable the integration of environmental concern and mitigation measures in the project development. EIA can often prevent future liabilities or expensive alterations in the project design. The EIA notification 2006, it lays out a detailed process for obtaining prior environmental clearance for any new project or activity or the expansion or modernization of existing project and projects seeking capacity addition with a change in process or technology. Projects or activity are categorized as A and B depending upon the extent of their capacity and size. For example, river valley projects of more than 50 megawatt hydroelectric power generation are project A, while river valley project whose power generation is between 25 and 50 megawatts are project B as per the notification. Speaking about the approval process, the approval of category A projects acquired their clearance from the MoEFCC, while category B project apply for clearance to the State Environment Impact Assessment Authority, that is SEIAA. The environmental clearance process consists of 4 steps of number 1 screening, scoping, number 3 public consultation and appraisal. Expert Appraisal Committee EACs are consulted at the central government and the state government or union territory level. These are called the State Expert Appraisal Committee, which screen, scope and appraise application for category A and category B project respectively. Category B project can be further broken down to B1 and B2, thereby determining which projects and activity will require an EIA before approval. Since January 2016, institutions have been created at the district level as well as they too have been included in the EIA notification for approving certain instances of mining of minor mineral. These are the District Environmental Impact Assessment Authority DEIAA and District Level Expert Appraisal Committee, that is DEAC. If we talk about the EIA cycle and procedure, the EIA process in India is made up of many phases. These phases are screening, then scoping and consideration of alternatives, then baseline data collection, after that impact prediction, followed by assessment of alternatives, delineation of mitigation measures and environmental impact statement, followed by public hearing, then environmental management plan, decision making and then monitoring the clearance condition. Now we will discuss one by one each process or phase of this EIA. First phase, as we discuss, is screening. Screening is the procedure to determine whether an activity is subject to EIA and the extent of the respective study. The EIA notification, it provides an initial screening which is based on quantitative threshold to determine the category under which a particular project will fall. Project under category A have larger potential impact on human health and natural and man-made resources or a larger spatial extent or potential impacts. They require an environmental clearance from the federal government or the MOEF. Category B project required an environmental clearance from the state government and also required further screening by the SEAC to determine whether they need a comprehensive EIA under category B1, a rapid EIA category B2 or no further studies. Second phase is scoping. Scoping is the procedure by which EIA scope and focus are defined either through consultation on planned activity with stakeholder and dissemination of information on the proposed activity, and to see if there is no specific procedure, the regulation define the minimum scope. The EAC and SEAC define the EIA scope of category A and category B1 projects respectively. Scoping, you see, is based on the information furnished by the project developer in prescribed format along with a draft TOR for the EIA, and on-site visits are necessary by the EAC or SEAC. Process of prior environmental clearance could be rejected by the MOEFCC or SEIAA if recommended by the EAC or SEAC at the scoping stage itself. Next is term of reference. Project development submit a draft TOR, term of reference, at the scoping stage to the EAC or SEAC. After reviewing the draft TOR or term of reference and information provided by the proponent as well as site visit if needed, the EAC or SEAC clears the term of reference with or without recommended modification. The EIA has to be conducted by an accredited consulting firm, with each EIA team member also need to be accredited. Next is requirement. The EIA must consider impacts on land, water, vegetation, fauna, air, aesthetic and socio-economic environment. The EIA shall determine the baseline for valued ecosystem component for the study area and assess the impact of the project either due to project location or possible accident, project design, project construction, regular operation, final decommissioning or rehabilitation of a complete project, as well as from the use of new and untested technology in the project and the impacts from technological failures. The next is alternatives. The EIA must include an analysis of alternative, including site and technology alternative. As far as institutional coordination is concerned, the MOEF and SEIAA are to base their approvals on the recommendation of EAC and SEAC respectively. The SPCB or State Pollution Control Board has the responsibility for conducting the public hearing. Sectoral agency of the state and federal governments as well as local governments have the right to participate in the public hearing. The dissemination process or the proponent disseminates the draft EIA report in hard and soft copies before public hearing. Final EIA report, which is also available at the MOEFCC or SEIAA. The MOEF or SEIA discloses minutes of screening, scoping and appraisal meeting on their websites. Minutes of the public hearing are available on the SPCB website. The EC along with the condition imposed is available on the MOEF and SEIAA website. The developer must advertise in national and local newspaper as to where the public could access the text of the EC or environmental clearance. As far as citizen participation is concerned, public hearing is mandatory for all categories A1 and B1 projects. Overall, public consultation is divided into two components. Number one, a public hearing at the site or in its close proximity, district-wise, to be carried out as specified by legislation for ascertaining concern of local affected person. And number two, additional consultation and obtaining written responses from the concerned persons having a valuable stake in the environmental aspects of the projects or activity. The mandatory public hearing is organized by the SPCB and chaired by the district administration, which prepare and finalizes the report on the public hearing. The proponent is required to address all material concern expressed during the public consultation and make any appropriate changes in the draft EIA or EMP, Environmental Management Plan. Speaking about Environmental Management Plan, the EIA report include an EMP which describe number one, all mitigation measures item-wise to be undertaken during the construction, operation and entire life cycle of the project to minimize adverse environmental impacts. And number two, the environmental monitoring plan for compliance of various environmental regulations. Number three, emergency or accidents management plan. Number four, social impact management and resettlement and rehabilitation plans. And finally, the institutional mechanism to ensure that the approved EMP or environmental management plan is implemented and effectiveness of such implementation is monitored. Next is monitoring and reporting. The MOEF regional offices undertake periodic monitoring. The MOEF and state regulators, whether it is SEIAA, DOE or SPCB as designated in any of the state, are responsible for monitoring and enforcing compliance with the EIA requirements. Supervision of the environmental aspects of the projects, activities and work is done as specified in the environmental monitoring plan and the EMP or as per additional condition imposed by MoEF on SIA. The project developer must submit half-yearly compliance report to the MoEF or SIA, which must include progress of implementation of the EMP. Speaking about EIA regulation, the Environmental Protection Act 1986 with subsequent notification rules and standard, Environmental Impact Assessment Notification 1994 revised in 2006, Coastal Regulation Zone Notification 1991 revised in 2011, all these are EIA regulations governing the EIA activity of different industries or different activities. The 2006 notification has also undergone changes over the years. As we know that on 23rd March 2020, the Ministry of Environment and Forest and Climate Change invited comments on a new draft EIA notification, and the draft notification, which seeks to replace the earlier 2000 notification, was made open for public comment for 60 days. However, because of lockdown due to COVID, the comment period has extended, and now after receiving all the public comments, the MoEFCC will take into consideration before finalizing and draft notification. So, to conclude this session, we have learned in this session the main environmental authorities which have key responsibility in the EIA process are MoEFCC, CPCB, EAC, Expert Appraisal Committee of MoEF, SEIAA, that is known as State Environmental Impact Assessment Authority, State or Union Territory Expert Appraisal Committee, State or Union Territory Pollution Control Board. The decision making responsibility is with MoEFCC and SEIAA. The process which are involved in the EIA are screening, scoping and consideration of alternatives, baseline data collection, impact prediction, assessment of alternative, delineation of mitigation measures and environmental impact assessment, a public hearing, environmental management plan, decision making and monitoring the clearing condition. The first phase is screening, and that second phase is scoping, which is a procedure by which EIA scope and focus. The third phase is terms of reference. Project developer has to submit a draft TOR or term of reference at the scoping stage to EAC or SEAC. The EIA must consider its impact, whether it is on land, water, vegetation, fauna, air, aesthetic and socio-economic environment. That EIA should have an alternative, whether it includes size or technology alternative. There must be an institutional coordination. There should be a dissemination of the draft EIA. It should be in the hard copy and soft copy before the public hearing, and it is also available with MoEF or CIA. There is a need for citizen participation or public hearing. Public hearing, as we know, is mandatory for all category of A1 and B1 project, and the mandatory public hearing is organized by SPSB and it should be chaired by the district administration to finalize, and it should have a environmental management plan, the EIA report, and EMP. It should have in EMP plan all the mitigation measures and what are the entire life cycle of the project, and it should also compliance with the various regulation. There should also be an environmental accidental management plan and institutional mechanism to ensure that approved EMP is implemented. And it should have a proper monitoring and reporting, and all aspects of the project report, activity, work done, it should be specified in the environmental monitoring plan. And the EIA regulation, which covers our Environmental Protection Act 1986 with various modification rules and standard, Environmental Impact Assessment Notification 1994 and revised in 2006, and Coastal Zone Regulation 2006. And the Ministry of Environment and Forest Change and Climate Change has also invited comments on the new draft EIA notification, and they will take all the comments before consideration before finalizing the draft notification. Thank you.